the shocking court case that changed banking forever. In 2020, a seemingly routine oil trade spiraled into one of Singapore's most stunning financial scandals. Two major banks, OCBC and Standard Chartered, refused to pay out millions under their letters of credit. Why? They claimed the entire transaction was built on fraud. What happens when the lifeblood of international commerce gets poisoned? When cargo that should be worth millions doesn't actually exist? This isn't just about Winson Oil and their battle against banking giants. This is about a legal principle that could transform how every international transaction works. The court's ruling sent shockwaves through the financial world. But what really happened behind closed doors? What red flags did everyone miss? And most importantly, could you spot the warning signs before it's too late? The answer might be more disturbing than you think. The shocking oil trading fraud that rocked Singapore's banking world. When three companies completed a simple circle of oil trades in just one afternoon, nobody suspected it would explode into a multi-million-dollar scandal that would reach Singapore's highest courts. Here's what really happened. On March 27, 2020, Hin Leong Trading sold 780,000 barrels of gas oil to Trafigura, who quickly sold it to Winson Oil Trading, who then sold it right back to Hin Leong. All on the same day. A perfect circle. But there was one massive problem. The oil didn't actually exist. How could trading companies sell something that wasn't real? The answer is both simple and shocking. Freddie Tan, an employee at Hin Leong, was instructed by his boss to forge bills of lading, the critical documents that prove cargo has been loaded onto ships. These weren't small forgeries either. We're talking about documents worth tens of millions of dollars. Instead of the ship captain or vessel agent signing these bills, as is legally required, Freddie signed them himself. The forged documents claimed oil was loaded onto vessels called Ocean Voyager and Ocean Taipan, but investigators later confirmed no such cargo was ever loaded. Winson Oil then used these fake documents to get letters of credit from OCBC and Standard Chartered Bank. Essentially, they were asking banks to finance phantom oil shipments. But how did Winson Oil get caught? This is where it gets interesting. Multiple red flags appeared that should have raised serious questions. The circular nature of the trades, the impossibility of producing original bills of lading, the mysterious change in oil quantity after the ships supposedly sailed. Even when confronted by OCBC that no physical cargo was shipped, Winson's reaction was suspicious at best. Rather than investigating deeply, Winson simply switched vessels in their documentation and tried again. The courts ultimately ruled that Winson Oil acted with reckless indifference to whether their representations were true. They weren't merely negligent. They displayed a level of indifference that constituted fraud under Singapore law. This wasn't just a paperwork error. It was a deliberate scheme involving forged shipping documents to finance non-existent cargo in a circular transaction that had no legitimate business purpose. The most disturbing part, this case exposed how vulnerable global trade financing really is. If sophisticated banks and trading companies can be entangled in phantom cargo schemes, what other financial deceptions might be happening right under our noses? And the even bigger question, after this landmark ruling, will international trade financing ever be the same again? The devastating consequences of Singapore's phantom oil fraud. The fallout from this case changed everything in international banking. First, Winson Oil lost both lawsuits against the banks. Their claims for millions in payments were completely rejected. But that was just the beginning. The courts ordered Winson to pay $200,000 in legal costs to the banks. a financial gut punch on top of their crushing defeat. But the real damage? Their reputation was destroyed. Who would trust a company found guilty of reckless indifference to truth in international trade? Meanwhile, the revelation of Hin Leong's fraudulent activities led to its complete collapse. Once worth billions, the company fell into liquidation, with founder OK Lim facing multiple criminal charges. The most shocking consequence wasn't financial, though. It was legal. This landmark ruling expanded what counts as fraud in letters of credit forever, sending shockwaves through the entire global trading system. But what lessons can you learn from this spectacular downfall? 5. Critical lessons from the Singapore oil trading scandal. So what can we actually learn from this massive financial fraud that changed international banking forever? Here are the 5 most important takeaways that could save your business millions. First, red flags are real. The most shocking part: all the warning signs were right there in plain sight. The circular trades completed in a single day, the mysteriously missing original documents, the inexplicable quantity changes after ships had supposedly sailed. When something feels off in business, trust your instincts. Second, due diligence matters. Winson Oil claimed they were just an innocent middleman, but the court didn't buy it. Why? Because they never performed basic checks that any legitimate trader would do. They never demanded inspection reports, never verified cargo loading, and most damning, when told no physical cargo was shipped, they just switched vessels instead of investigating. But here's where it gets really interesting. Third, courts don't care about technicalities when fraud is involved. The famous legal principle, fraud unravels all, means that technical defenses crumble when dishonesty is proven. Once the courts saw Winson's reckless indifference to truth, nothing else mattered. Fourth, digital trails are forever. Those WhatsApp messages where Winson executives worried about clean title, the emails showing they knew about problems but proceeded anyway, all became devastating evidence. In today's world, assume everything you write will someday be read in court. But the final lesson might be the most valuable of all. Fifth, the definition of fraud is expanding. This landmark case established that reckless indifference to truth now counts as fraud in international trade. You don't need to personally forge documents. Simply not caring whether information is true can make you legally responsible. The question isn't whether another massive trade finance fraud will happen, it's when. And when it does, will you spot the warning signs before it's too late? What other financial frauds might be happening right now using these same techniques? Fraud happens. It could affect any business, anywhere. And the consequences? Well, you've just seen how devastating they can be. That's why we're on a mission to help you understand these financial crimes through real court cases like Winson Oil. Because let's face it, learning from someone else's mistake is a lot cheaper than making your own. If you feel lucky today, let's continue with our trivia time. We will provide you with 3 challenging questions to test your fraud detection skills. Question 1. What action should a trading company take when a bank rejects their documents claiming no physical cargo was shipped? A. Switch vessels in the documentation and try again. B. Immediately contact the shipping company for verification. C. File a lawsuit against the bank for wrongful rejection. D. Keep submitting the same documents until the bank accepts them. We will give you a few seconds to think. Correct answer: B. Immediately contact the shipping company for verification. Why B is correct? This directly addresses the due diligence lesson. A legitimate company with nothing to hide would immediately investigate such a serious allegation by contacting the shipping company to verify the cargo's existence. Why other answers are wrong? A is wrong because switching vessels without investigation shows reckless indifference to truth, exactly what Winson did. C is wrong because filing a lawsuit without verifying facts, first, only creates more legal exposure. D is wrong because persistence without addressing the underlying concern demonstrates willful disregard for truth. Let's continue with question 2. In a circular trading transaction, which of these would not be considered a red flag? A. 3 companies completing a full circle of trades on the same day. B. The final buyer paying a higher price than the original seller received. C. Independent inspection reports verifying cargo quality at each transfer point. D. Using letters of indemnity instead of original bills of lading. Correct answer: C. Independent inspection reports verifying cargo quality at each transfer point. Why C is correct. Independent verification is actually a safeguard against fraud. If legitimate third parties inspect and verify the cargo at each transfer, this would establish the cargo actually exists. Why other answers are wrong? A is wrong because same-day circular trades are highly suspicious and rarely have legitimate business purposes. B is wrong because price increases through a circular trade with no added value suggests artificial inflation. D is wrong because substituting LOIs for original BLs without good reason is a classic red flag in trade finance. And now for the last question. Under the expanded definition of fraud established in this case, which situation would most likely constitute reckless indifference to truth? A. A trader who accepts documents with minor typographical errors. B. A trader who proceeds with a transaction despite being unable to verify the cargo's existence after multiple attempts. C. A trader who relies on a long-term partner's representation about cargo quality. D. A trader who accidentally submits outdated certificates. Correct answer: B. A trader who proceeds with a transaction despite being unable to verify the cargo's existence after multiple attempts. Why B is correct. This perfectly captures reckless indifference as established in the case. Continuing a transaction when you've tried but failed to verify the cargo exists shows conscious disregard for whether your representations are true. Why other answers are wrong? A is wrong because minor typographical errors are typically considered negligence, not fraud. C is wrong because relying on trusted partners with a history of reliability is generally reasonable conduct. D is wrong because accidentally submitting outdated certificates is negligent, but not deliberately indifferent to truth. Remember, the courts now look beyond whether you personally created a false document. They examine whether you cared about the truth at all. That was it for this episode. Hope you liked the content. Hit subscribe, tap that notification bell, and leave a comment below telling us which financial crime case you want us to break down next. Because remember, in the world of financial crime, what you don't know can hurt you. Stay safe, stay informed, and we'll see you in the next video.